Good morning. The Hearing Board of the South Coast Air Quality Management District is in session. Today is Thursday, March 28th, 2019, and the time is 10 o'clock a.m. We are meeting in the Hearing Board room in Diamond Bar. We have one matter on the calendar today, and it's on the consent calendar, and that is SCAQMD versus Providence Tarzana Medical Center, case number 6128-1. And it's for a modification of the order for abatement that is stipulated between the parties. Board members, we received several documents, including which was date stamp March 26th at 12:19 p.m. Stipulation to place the matter on the consent calendar between the parties, which was timely. The parties have agreed to the following. First, that the petition for order of abatement may be heard on the hearing board's consent calendar. Second, that the declaration of Van Duong may be admitted into evidence. So we're going to mark the declaration of Van Duong, which includes several attachments. We're going to mark that a declaration and its attachments as Exhibit A, as an apple, for respondent, since Van Duong is a consultant to Providence Tarzana Medical Center. The parties further agree that they have stipulated to the proposed findings and decision that have been lodged with the hearing board in this matter, and that the document may be marked as an exhibit. And so we're going to mark the proposed findings and decision for modification of the stipulated order for abatement that we received as exhibit number 2 for the petitioner, for the district. And finally, the parties agree that the proposed order is not expected to result in violation of Health and Safety Code section 41-700, which is nuisance. And I assume all board members have reviewed the papers, and I believe that based on the declaration of Van Duong, that the minor modification to the schedule, which is requested in the modified or proposed modified stipulated order for abatement, that there's good cause for that, and that it's supported by the documents. Just to remind ourselves where we are. Oh, first of all, I should have, before I jumped in, I should ask, we're sitting with an empty hearing board room, so I did not ask, but since we are webcast, I should just say there's nobody here, so there is no public comment. Back to the matter. So we may recollect, hold on, that this deals with a nonprofit hospital with almost 250 beds and includes 2 medical office buildings, and that back in January of 2014, the medical center installed an emergency generator and applied in 2016 for a permit to operate, but that permit was subsequently denied in February of 2018 by the district, which means that the medical center has now been operating a generator without a permit. Back in April of 2018, the medical center began procuring a new emergency generator as part of overall upgrades to the medical center. And we entered, I believe it was January of 2019, or at least it was earlier, we entered the stipulated order for abatement. The medical center has been in compliance with that for the most part. It had an early fabrication. We had required the fabrication of the new generator on or before March 1st, and in fact, that was completed in January 2019. They also applied timely for a permit to operate the new generator, and that permit has already been issued. It was issued on January 16, 2019. The medical center also completed many construction activities that were needed to allow the installation of the new generator. The problem comes in that there were heavy rains, and as a result of those heavy rains, they lost 23 working days for some of the foundational work and other activities that cannot be completed when there are heavy rains. So the request is not to extend the final deadline by which that generator needs to be operational, and the generator that is not permitted needs to be removed, but rather just one of the interim dates, which is the installation incremental progress deadline, which was April 1st, 2019. The request is that because of these rain delays, to allow to May 1st, 2019. And I think that the supporting documentation shows with enough evidence that that there's good cause to allow that, and in particular, given that they are not requesting a change in the final date for being in full compliance with the new generator and turning off the old one. So with that, I believe we can find good cause. Anyone else wish to? Ms. Byrd?
I would agree that we can find good cause based on those items. I just wanted to just add one thing, that the use of the emergency generators for power for the operating rooms and parts of the emergency department. So I believe that we can find good cause. And as you mentioned, the excavation and soil work could not be done because of the rain, and it's common knowledge that we know we just have a ton of rain. So I think that we can make the findings.
Thank you for the excellent additional points. Senator?
And likewise, they've gone beyond what the requirements would have been in working in concert with the seismic study that was from the California Office of Statewide Health Planning and Development to retrofit the building. They're working with the city of LA, which would grant them the permits to provide that work. And the work was, the legislation was adopted by a guy named Senator Al Alquist, who was my seatmate. Thought I might put that in. Anyway, it's a good idea.
Thank you. Anyone else? Mr. Balagopalan?
I just wanted to point out, so in the order, what has been changed is the condition F in the order, which will change the, respondent shall install the new generation and schedule inspection of the washpot on or before May 1st, 2019. Previous order had April, so that's the change. So it's a 1 month, essentially, extension.
That's right. And then that will be clarified in a motion, but yes.
Oh.
Yes. Any
No,
additional?
no.
Okay, any other thoughts?
No, they still working on Saturdays and weekends, double schedule, so it can still meet the deadline. And they saying they will do that as specified in the order, which is really very good.
I agree, and I think the credibility is very strong when they've already completed portions of this order in advance of the deadline set. So I think we can feel very good about the fact that they are going to work very hard to make sure they meet that final deadline and aren't requesting any extension. Okay, so with all of that, I'm going to make a motion, and that is in the matter of South Coast AQMD versus Providence Tarzana Medical Center, case number, is that correct? 6128-1. I move that we grant the requested modification to the stipulated order for abatement based on good cause, as was just discussed, and that modification will be to the order condition 1F, and it will read that respondent shall install the new generator and schedule an inspection with OSHPD on or before May 1st, 2019, changing April 1st to May 1st. No other changes, and that completes my motion. Is there a second?
I'll second.
Ms. Byrd seconds the motion. Any discussion on that motion? Senator, how do you vote? Aye. Dr. Lerner, how do you vote?
Aye.
Mr. Balagopalan, how do you vote?
Yes.
Ms. Byrd votes
Yes.
I vote yes. Motion passes 5-0. And thanks to the parties for putting it together in a nice consent package. I think this was an excellent example of a case that can be on consent. Did you have additional? Okay, one other, so we're done with that case. I just wanted to note without any discussion of it, but just so that board members are aware to please wait and you'll receive copies of all of these, both of these, which I'm going to talk about, and also instructions on what to do with them. Okay. Next week, we are hearing an order for abatement for Gold Coast Baking Company. And Gold Coast Baking Company made a motion to present evidence that is confidential and trade secret in the form of a declaration with attached exhibits. And I ruled on that motion based on a declaration that they, in fact, are keeping that information secret and that it would harm them for anyone else other than those people who they specifically have, in the past, given that information to, if that information is given to the general public. So as a result, we're going to follow different procedures than we do for all of our public hearings. All board members will receive an unredacted, we're going to call it, declaration, which will be marked on the top, confidential and privileged, trade secret, confidential business information, and it will be kept that way. And I will ask, in addition, you're going to receive a copy of my pre-hearing order in this matter, and on the second page, numbered 1 through 8, are the procedures by which we will follow with regard to this information. Please be 100% familiar with how we are handling this information, including please keep your version of the declaration confidential and privileged, and at the conclusion of the hearing, we will return these declarations, all the copies, which will then be returned to the respondent. In addition, we're not going to be filing in FIND a copy of the unredacted version of the declaration. It is not for public consumption, and it will be filed in district council's files, not in the files of the hearing board. And the hearing board will be filing what we're calling redacted versions, which will simply state that they are in fact confidential and privileged documents and that they have been redacted. And please familiarize yourself again with these steps 1 through 8, because our questioning during the hearing will not be specific. We will not refer to any of the specific confidential information, no numbers, and nothing that would reveal this confidential and privileged information. Rather, our questions will need to be very general, such as we will have the declarant on the witness stand, and you can ask the declarant, is this information correct? Something very general, but nothing that would elicit or otherwise demonstrate what the content is of that confidential and privileged information. And then the final step will be, if we feel we do not have sufficient information, then the respondent will have an opportunity to continue the hearing and submit an additional confidential and privileged declaration, which will answer specifically questions we may have. Okay? We don't want to have a whole conversation about it because we don't have the parties before us, but do you have a question? Just basically, please read the procedures and keep the declaration confidential.
Based on your statement and the procedures, it appears that this hearing should be in closed session.
No, we don't have closed session. Hearing board has no
Oh, you need
rules.
to
We don't have rules for closed session.
No, but if there should be alleged, if it's subsequently alleged that there was a violation of the confidentiality inadvertently, but yet a violation, then what would be the response?
Okay, we're not going to have this discussion because the parties are not present. I will say this. I did not make this decision on my own. I did not make this decision or ruling in one pre-hearing. We had 2 pre-hearing conferences, and I consulted with our outside counsel, who is an expert in the Brown Act and its implications. And so my ruling is completely in line with that which we can do and not beyond our powers. I don't want to have the discussion further than that. I just wanted to alert everyone's attention to how we're going to do this. Please make sure you read it, you will receive it, and the declaration to make sure we all keep it confidential. And with that, I'm going to
one
adjourn.
member-
With that, I'm going to adjourn for the day because I do not want to get into the conversation.
No, please, this is appropriate.
It is not appropriate. There are no parties here. We're not arguing.
Statement I'm going to make is appropriate.
Okay.
I, for one, would certainly adhere to the ruling of the chair and all those parties concerned who discussed it with her prior to the discussion today. My only statement was that if it's inadvertently, unintentionally, something slips, that's all and I want to raise that point because
Okay.
you could.
And I appreciate that, and that's why I want to make sure everyone is very familiar with the process that we have established, because we do not want to let that slip, and we have to be very careful in our questioning. And so that's why we need to be very familiar with how it's going. That's the only reason why I've raised it outside the hearing context.
Ask
But
you a question?
Yeah.
Has this confidentiality ever been presented to, required of the board previously? I've not been here.
I believe it has been requested before.
And acquired.
I don't recall, but it's my
don't recall.
understanding that once before it's happened. But I don't recall it. I'm not sure if I was here for it. But outside counsel tells us we are allowed to do it this way, and so we will proceed in that manner. Okay, we are adjourned. Thank you all.